Hi, I'm Rusty Messer from the law firm of Rusty Messer and Associates. We're a personal injury firm in the Baton Rouge area. People often ask me about what an insurance adjuster says versus what an insurance adjuster actually means after an accident. So that's what we're going to talk about today. An insurance claims adjuster will employ a variety of negotiating tactics to get you to settle your claim for as little as possible. Let's look at 4 statements the claim adjuster might make in conversations with you, and then let's talk about what those statements really mean. First, when the adjuster says, "I'd like to take a statement," what the adjuster really means is, "I want to pin you down to one version of your story right now." And the reason the adjuster wants to do that is because it may take some time before your injuries to develop. The adjuster is going to try to use that against you later if you try to add additional things that you forgot. Do not let the adjuster pin you down to making a statement. The adjuster is going to try to get to you as soon as possible after the accident. They want to catch you while you're still in shock or before your symptoms have fully developed. The adjuster will use your statement to A, commit you to a version of what happened, B, question your credibility if you correct an innocent mistake or add an overlooked detail later, and C, look for interpretations that reduce your claim's value, and also to disprove injuries that you suffered which get worse after your statement is given. The second statement, when the adjuster says, "Please sign this medical authorization form," what he or she really means is, "Please sign this form so that I can gain access to your entire medical history, going back to the womb, and perhaps find something I can use against you." Adjusters frequently ask claimants to sign a medical authorization. This gives the adjuster permission to obtain copies of your medical records, and the problem is that most of these insurance company authorizations are broadly drafted. This gives the adjuster the ability to go into a claimant's complete medical and psychological history as opposed to just obtaining the records related to the treatment for your accident. This allows the insurance company to pry into pre-existing conditions and medical or psychological issues, and most claimants who do not have a lawyer will sign these medical releases because they think that if they cooperate with the adjuster, this will increase their chances of getting a prompt and fair settlement. But usually signing will come back to bite them later. 3, when the adjuster says, "Why do you need an attorney? I'll work with you on the claim," what he or she really means is, please don't call an attorney. When an attorney gets involved, it becomes much harder for the adjuster to push you into a fast, cheap settlement. When the adjuster deals with an unrepresented claimant, the adjuster has the upper hand because he knows how the system works and he has been trained in negotiation. Once a personal injury attorney gets involved, the adjuster loses his or her advantage. As a result, to discourage you from contacting an attorney, the adjuster might say, "Your claim won't be any more valuable just because you get an attorney." This is false. The price tag of a claim almost always goes up when an attorney gets involved. Or the adjuster might say, "Why do you need a lawyer if I'm looking out for your best interest?" But not true. The adjuster is looking out for the insurance company's best interest, and he or she wants to pay you as little as possible. The adjuster might say, "Well, if you get a lawyer, we're going to have to hire a lawyer and take your deposition." That's true. But if the case proceeds as far as a deposition, it's just going to be you sitting by your attorney, giving your statement that your attorney has prepared you to give. Or the adjuster might say, "If you hire a lawyer, it will slow down the claims process." This is also true, but it's also likely to result in a much more fair outcome. The fourth statement is when the adjuster says, "If you don't accept this amount now, we will withdraw all offers." What he really means is, "Please take this low offer so I can get this file off of my desk." And this is often a bluff, because if your case is worth $20,000 today, it's going to be worth at least $20,000 tomorrow, next month, and next year. If it's not a bluff and the adjuster does withdraw the offer, it's just an invitation for your attorney to file a lawsuit. To recap, don't give a statement. They require limiting language on any medical authorization form you sign. You understand the adjuster really does not want you to hire an attorney, and do not fear the adjuster's threat to withdraw all offers. Compare the last offer that the adjuster made to what your case is actually worth, then you decide whether or not to accept an offer. If you need help in evaluating your claim, you can give us a call to discuss it. There's never a charge for the consultation. You can reach us at 225 963 9638.